that people are still joining, so I'm going to wait a minute for people to get onto the call. Okay, well, good afternoon, everyone. I'm delighted to welcome you to our speaker series today. I'm going to just share my screen here for a moment, so bear with me. Hopefully you can see my screen, everyone. Let me start by just introducing myself. My name is Angela Riley. I am from the Citizen Potawatomi Nation in Oklahoma, and I'm a law professor, of course, here at UCLA and director of the Native Nations Law and Policy Center. I am delighted to join, to welcome you to our event today. I wanted to start by just showing you the slide that I'm showing you here. This picture is from where I was raised. This is my family farm in Southwest Oklahoma in Kiowa County. And I'm sort of surrounded, and as I'm taking this photo, I'm surrounded by Saddle Mountain and Rainy Mountain and Green Valley and my home, my family home. So this is where I'm from. We're delighted that you are here joining us today for our Red Rising speaker series. We have actually had to go online, as many of you have as well, and we've turned our Red Rising conference into a series of events that have been really remarkable and fantastic throughout the semester. We've already had a couple of them you can see on the slide here. Today, of course, we'll be talking about the UN Declaration on the Rights of Indigenous Peoples. And we have two more events coming up that I've highlighted here. So if you have an opportunity to take a note of those, we would love to have you. Let me just start by introducing our esteemed panelists. As I mentioned, today we are going to be speaking about the UN Declaration on the Rights of Indigenous Peoples. Many of you are probably familiar with the declaration. It passed the UN General Assembly in 2007 and was endorsed by the United States in 2010. And our panelists here today are absolute visionaries, path breakers, both in terms of the long view, helping the declaration in terms of its draft form and ultimately be endorsed by the United States, as well as implementation of the declaration around the world and in US legal systems. So without further ado, let me introduce our esteemed panelists. First, we have Kristin Carpenter is the Council Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. Professor Carpenter serves on the UN Expert Mechanism on the Rights of Indigenous Peoples as its member from North America since she was appointed in 2017. She's a graduate of Dartmouth College and Harvard Law School. She was a founding member of the campus-wide Center for Native American and Indigenous. She's an elected member of the American Law Institute and serves on the Federal Bar Association's Indian Law Section Board. And I would be remiss not to also mention that Professor Carpenter is my very frequent co-author, co-everything, former co-NALSA chair in law school, and my closest professional and personal confidant. So I'm delighted to welcome her here today. I'm also delighted to welcome someone who really needs no introduction, an absolute leader and visionary in our field, Walter Echo Hawk. Walter Echo Hawk is from the Pawnee Nation. He's a Native American speaker, author, and attorney. Walter Echo Hawk is currently the president of the Pawnee Nation Business Council. He's a well-known Native American attorney, tribal judge, author, activist, and law professor. He's represented Indian tribes and Native nations on some of the most important issues that we faced as Native people for decades, including treaty rights, water rights, religious freedom, prisoner rights, and rights to repatriation. His career spanned the pivotal years when Indian tribes reclaimed their land, sovereignty, and pride in a stride toward freedom. Walter is the author of many books, among them In the Light of Justice, The Rise of Human Rights in Native America, and the UN Declaration on the Rights of Indigenous Peoples. We are absolutely delighted to have both speakers here today. What I would like to do at this point is turn the conversation over Let me stop sharing my screen so that you all can see our speakers. What I would like to do first is turn the conversation over to Walter Echohawk. And Walter, I would love it if you would give us some of the background and context about the drafting and development and ultimate endorsement of the Declaration by the United States, and to kind of give some general idea to our audience what this fight for human rights and Indigenous rights has been like and why it's so important for Native nations today. Thank you, Walter.
Thank you. Thank you very much for having me on this program, Professor Riley. I'm deeply honored and deeply honored to be here on the UCLA channel, very prestigious college in our nation, and as well as serving on this panel with Professor Carpenter. You two are leading scholars in federal Indian law, and it's really my pleasure and honor and privilege to work with you on this panel. And especially on such an important issue, you know, this UN Declaration on the Rights of Indigenous People is a landmark international development because it's really the first time that through the work of Indigenous peoples going to the UN, working for over 30 years, marching through the UN framework, have really produced a landmark document for Indigenous peoples worldwide, including here in the United States, because it's really the first time, the first significant effort of making international law accountable to Indigenous peoples. And it just goes to the body of modern international human rights law and draws from the UN treaties and norms, existing human rights, and puts them in this UN declaration so that Native people, for the very first time, could get the same kind of inherent human rights that the rest of the world already takes for granted. And so I think this is very, very, very important for Indigenous peoples here in the United States, as well as other nations around the world, because the Declaration creates a comprehensive framework for human rights. And as such, the goal of it is to really be an antidote to this legacy of colonialism, and to create a human rights framework so that we can discard, nations can discard that legacy of colonialism, together with the inferior legal rights and the dark side of the law pertaining to Native people that was derived from, you know, the law of colonialism. And so if this landmark declaration is fully implemented by each nation around the world, and currently 150 nations around the world have endorsed it, it will really change the way the world looks at Native people and reshape the world for a better place. And this is a very important contribution to international law. It asks each nation, including the United States, to work in partnership with Indigenous peoples to implement these minimum human rights standards into domestic law and policy. And so it's very, very significant that this was endorsed by the United States under President Obama in 2010, making it technically already a part of US policy, but it remains to be implemented in consultation with Native America. And that's the challenge of the day. So we stand at a crossroads here between international and domestic law. It's a very historic moment in time, a lawmaking moment for Native America in the history of our legal rights to reach out and grasp this human rights framework as a means to strengthen Native American rights in our nation. And so it brings great hope to our people in these dark and uncertain days. You know, we can see two legal frameworks now for defining our legal rights. Our existing framework of federal Indian law, which came to us from the law of colonialism. Yes, it has some strong features, but yes, it has a dark side. And then now on the horizon, we can see this brand new human rights framework. And so the ball is in our court in Native America to grasp that opportunity to create a law and social justice reform, law reform movement, and march into the human rights realm. And so I'm very excited about that idea, and both Professor Riley and Carpenter are among those legal scholars that are paving the way for this. And so I'm grateful to be here, looking forward to the rest of the panel. Thank you.
Thank you very much, Walter. And I'm going to circle back around to you with some follow-up questions, but we'll take some introductory remarks from Professor Carpenter. Professor Carpenter, I know that you have been serving as the North American representative on the expert mechanism on the rights of Indigenous peoples and recently stepped down as the chair. So I'm wondering if you can give us sort of more of a bird's eye view in terms of how you see the UN Declaration moving the needle in regards to Indigenous rights around the globe, and then I guess to circle back to Walter's point to talk about how you see it really the possibilities for the implementation of the Declaration into U.S. domestic law.
Thanks, Angela, and thanks for the kind introduction and opportunity to be here today, as well as with Walter Echohawk. It's really an honor to share the stage with both of you. Walter has been such an inspiration in his many years of advocacy and really inspiring many of us to take up this mantle in terms of implementing the Declaration here in the United States. But looking globally, over the last 5 years, I have had tremendous opportunities to work on Indigenous rights around the world and met people from the Khoisan people in South Africa and Karelians of Russia to Nahua people in Mexico, Karen people in Thailand, and really dozens of others who are all advocating both at home and in international and regional human rights systems. And I think what I've learned, what's most fundamental to me, is that the United Nations was founded after World War II to promote peace among peoples and human dignity within individuals. And those values are expressed in the UN's Charter, in the Universal Declaration on Human Rights, many international treaties and covenants. And I think as Indigenous peoples increasingly had opportunities to become involved in those forums, they sought to articulate how those values of peace and human dignity could be realized in their contexts. And so as Walter was saying, the Declaration on the Rights of Indigenous Peoples culminated through decades of advocacy and really in 46 articles articulates what it would take to make those universal values of peace and human dignity meaningful for Indigenous peoples following conquest and colonization, seeking remedies and seeking legal reform that would enable them to thrive today. And I'll just suggest a few examples, maybe articles from the Declaration and some moving the needle moments, as you said, Angela. So Indigenous peoples asserted that peace and human dignity would require states to recognize them, to recognize their rights of self-determination, not only as defined by international and national laws, but also as defined through their own Indigenous laws, customs, and traditions. And I think that's a key aspect of the Declaration, that it does recognize Indigenous peoples' own laws as a source for all of this work. And just as importantly, Article 7 of the Declaration recognizes the collective and affirmative right of Indigenous peoples to live as distinct peoples. This is such a different starting point from many national legal systems, including our own, wherein US Constitution states, for example, where focuses on Congress's power to regulate trade among states, foreign nations, and with the Indian tribes. And this power has sometimes been interpreted as plenary power, even to break treaties or violate Indians' property and sovereignty. A fundamental affirmation of Indigenous peoples' rights to live as distinct peoples and enjoy self-determination is a different starting point, and it's an empowering point from which to consider the components of life that are meaningful for peace and human dignity. And this, of course, includes self-governing institutions, spiritual relationships with land, economies, religions, and so on. And I think Indigenous peoples are really insisting through advocacy in all realms, their own courts and legislatures, national litigation and lobbying, and international advocacy for the opportunity to make those points in the Declaration real in their lives. Two recent examples that I'll mention before passing the baton back. Articles 11 and 12 of the Declaration go to Indigenous peoples' rights to repatriation of human remains and cultural objects. And we have a tremendous advocacy effort and a wonderful statute here in the United States, the Native American Graves Protection and Repatriation Act, in no small part because of Walter Echo Hawk's advocacy. And I know you all at UCLA and the California schools have been deeply involved in that work domestically, but there are international challenges too. There are thousands of ancestors in museums across the world, and the Declaration provides a vehicle for Indigenous peoples to insist on repatriation across national boundaries. MRIP recently had a major matter with the Yaqui people, a cross-border people in Mexico and the United States, who worked to achieve an agreement in principle with the government of Sweden regarding repatriation, and hopefully to pave the way for an international mechanism to address those issues. Of relevance also to your theme on political participation, the Human Rights Committee recently considered a claim from the Sami people in Finland regarding their Sami Parliament and the right to determine their own members of their community to have meaningful participation in their national government. I think this is a critical point, political participation, and one that we're also reflecting on in the United States as we're thinking about how tribes can participate in our national lawmaking system, and perhaps even specifically in a more direct way to think about implementation of the Declaration as an aspect of that. I could go on and on, but I'll pause at the moment. Thank you.
Well, thank you so much for that, Kristen, and Walter, with those opening comments, giving us a sense of the scope of the Declaration and its possibilities. I guess I want to, Walter, turn back to you for a second and ask you, I'm going to, selfishly ask you questions that I've always wanted to ask you, and I don't think I've had a chance to ask you. So I'm going to take this opportunity to do that. You've been such a visionary and such a leader in the field for so long. And for those of us who are, coming behind you, and I know there are a lot of students on this call watching this webinar as well, I'm really curious, I guess, to have your answer to two questions, one specifically related to the Declaration and one more broadly. So I guess the first question is, can you tell us how you did it? All of those enormous changes, the incredible successes that you had, the battles that you fought. And I guess part of that is thinking in terms of advice that you would give in terms of coalitions and allies, and whether strategy is best taken through the courts or through legislation. So sort of just, giving a little bit of an overview of how you see your own career in terms of the enormous successes you've had, but also the advice that you would give us. And related to that is around the Declaration specifically, what do you see as the greatest challenges for implementation of the Declaration into United States domestic law, and then also the greatest path in your view for success? So I know that's a big career spanning question, but take any part of that you want.
I thought this was going to be an easy question. Wow, that's a big question. I have been, I guess, very blessed, to have a long legal career. And I would certainly hope that all of the law students that are coming through the law schools and into the field of law will also enjoy a long and successful law career as well, because they are certainly needed in the 21st century to take up the mantle representing tribes and Native peoples here in the United States. And, we have a lot of challenges out there in the world today. Big challenges, that sit before us, and that this generation of Native leaders and attorneys are going to have to be facing. And I know that in my day, when I came out of law school, the challenge of the hour was, when I was a law clerk at the Native American Rights Fund in 1970. This was the summer when Richard Nixon handed down the hallmark Indian self-determination policy, which was a crowning success of a lot of years of advocacy by Native leaders to break from federal policies of termination and integration, and that's assimilation, I should say. But the challenge was to actually implement that policy into federal laws and statutes and court decisions and regulations, so that the reality of self-determination would be spread to each tribe across the land. And that became 2 generations worth of work. And I was very fortunate to be a young Native lawyer at that time. I think I was at the right place at the right time at the Native American Rights Fund. And I was fortunate to have good mentorship, by attorneys, young attorneys back then, who are now looked upon as giants in the field. But I have found that a solid legal education with good mentorship makes a big difference. But that Native advocates also have to be a complete person in terms of taking care of themselves, not burning out, have a good health, have a good heart, have a good mind, have a good spirit, and a solid foundation in your culture to take a long, successful legal road as an advocate and in this adversarial profession that we're in, and bank to bank hard on your cultures along the way, because it will show you the right path ahead when times get tough. And so that's kind of the tack I went. I was also very blessed to have excellent co-counsel at every turn in every matter I was involved in, working as part of a team of fellow lawyers, and I could not have done any of the achievements that I have accomplished without my co-counsel at my side, and so I'm indebted to them as well. So you'll find that you rely heavily on your colleagues and your cultures along the way. And but today I think we still stand here at Native America at the brink of a brand new human rights era. Just like I stood at the brink of a Indian self-determination era in 1970. And so your challenge today is to move forward to implement this human right framework into U.S. law and policy. And that that will probably take possibly a generation to do. And I know our future is in good hands, that we will be going forward, and you will be taking a very major role in it. During that march to justice, champions will be made, heroes will come forth, and I hope this generation of law students will be among them as your hallmark. And so I'm very optimistic because of this hope that this declaration offers to strengthen federal Indian law. There can be no stronger legal right than an inherent human right. And so if you look at all of our rights of self-determination, self-government, land, culture, language, religion, et cetera, as inherent human rights, then we will have a safe place in our society in this coming century. And I think it starts in Indian country, this march to justice. And along the way, we want to change the way that America looks at Native people and Indigenous rights as human rights. And so we have big challenges. And so big challenges also create big opportunities, and so I feel like the recent establishment of the national project to implement the Declaration in the United States, which was recently founded by the Native American Rights Fund and the CU School of Law in Boulder, is a very good sign, a very significant step in that direction. And I'm hoping that all of Native America will line up behind those efforts, so that we can march into the human rights realm.
Thank you so much for that, Walter. And I really appreciate your insight and, of course, your optimism. I think it takes a lot of grounding, as you said, in your culture and who you are to remain centered and also to remain optimistic. And so we always look to you as a point of inspiration. So thank you for that. I want to build off a little bit of something that you mentioned, which is the project to implement the UN Declaration into U.S. domestic law. As Walter mentioned, this is a project that is inspired by a collaboration between the Native American Rights Fund and the University of Colorado Law School, with Walter and Kristin Carpenter and other people, including John Echohawk and others who are working on this project. I'm going to turn in a little bit to a piece of that project, which also involves UCLA School of Law and me and my students and colleagues on tribal implementation. But before I do, Professor Carpenter, Kristen, could you talk a little bit about the implementation project that Walter mentioned and what you see its goals and purposes and avenues for success to be?
Sure, thank you. And this is, I think, a social and legal movement in Indian country where a group of really committed advocates, tribal leaders, ceremonial leaders, students, lawyers, law professors have gathered together to bring some of those aspects of the international human rights movement back here to the United States, and really to seek to implement the Declaration in our own legal system. And together with the Native American Rights Fund, the University of Colorado founded this joint project to implement the Declaration in 2018. And we started with a major conference, bringing together lots of those constituencies that I've mentioned. And there's now a good bit of information online, and perhaps in the chat we can post the website for the NARF CU project to implement the declaration. But the project has two prongs. It's devoted to education and advocacy regarding the declaration and its applicability here in the United States. Our first publication was a report that is meant to put the declaration in context, both historical and legal, so that people in the United States gain a sense of its status and its potential for law reform, as Walter has outlined here, both immediate and going forward. And we are trying to do our education and advocacy through multiple media and forums. We had originally hoped to have a real strong presence, taking a team out to Indian country. That has turned into an online presence because of COVID-19, of course, and webinars and videos and publications and so on. And as you've already alluded, Angela, we are now focused on implementation in tribal communities, and I'll let you say more about that. But I guess the overall point is we're trying to bring together resources for those tribes, tribal leaders, attorneys, as well as others, people working in federal government, in state government, and law firms, law schools, who may really be interested in how can the declaration help. Whether that's in sacred sites advocacy, as the Navajo Nation Human Rights Commission has used the declaration, or perhaps it's in working with federal agencies around making consultation a better experience. I think one really important thread that it's important to identify is that we have many federal statutes out there, the National Historic Preservation Act, NEPA, and so on, that require federal agencies to consult with tribes regarding undertakings that may affect their land or their resources. But in many incidents, the most famous one is probably the Dakota Access Pipeline at Standing Rock. That consultation process has really failed to elucidate and honor tribal perspectives on their most sacred and fundamental rights. The UN Declaration would require moving to a standard of free, prior, and informed consent, which means meaningful agreement, mutual agreement. And I think this, among many other areas of advocacy, is a sweet spot for implementation here in the United States, where we could really transform existing legal standards in a way that is deeply meaningful and important in some of the most critical cases. Once again, I could say so much more. There's so many avenues where the declaration is directly relevant to projects, to cases, to strategy that tribes and tribal lawyers have in front of them. But that's kind of the general gist of the project, as well as some of our thematic focus at the moment.
Thank you, Kristen. Well, I think that's a great segue into another piece of the implementation that we want to talk about before we open it up to Q&A. I know there are some questions in the chat. But I did want to just say a word about this collaboration that we have between University of Colorado Law School, Native American Rights Fund, Walter and his work and his team, among other tribal leaders in Oklahoma who are working with us closely, and UCLA School of Law, Native Nations Law and Policy Center, all working together to work on a tribal implementation toolkit. So the idea behind this is to really start with the implementation of the UN Declaration at the most fundamental and basic level that we consider to be really the place where Native nations can lead the way and really set an example for how the Declaration can be implemented. So we've been working on a tribal implementation toolkit for all summer and for the last several months before the summer hit. We were really unfortunate because of COVID to have much of our clinic work at UCLA School of Law derailed, which left us the capacity to hire students to work remotely to help us put together the toolkit. And of course, we also had students working from Colorado Law School as well. So this has been a really exciting project. We've been able to engage some of our students around this. We are still in the process of putting it together, working with other leaders to get this ready to present it and roll it out. It's going to be a process, but we're really excited about it. So I wanted to just take a second. I kind of sprung this on her, but I'm really delighted to introduce Lauren Van Schulfgaard and ask her to say a few words. We are incredibly fortunate at UCLA. Our Tribal Legal Development Clinic is currently being funded by the San Manuel Band of Mission Indians, and their generosity has allowed us to have a full-time clinic director. And that director is Lauren Van Schulfgaard, who is my former student, and is now teaching that clinic and supervised the students directly over the summer. So I asked Lauren and invited her to, if she didn't mind, to come onto the Zoom, and she was willing to do it, to say a few words about the toolkit and the work that you supervised with the students and how you see that going. And when you're done, I really want to hear from Walter and Kristen again about why it's important to implement at the tribal level and what the significance of that is. But let me first turn that over to you. Thanks, Lauren.
Thank you, Professor Riley, and thanks for letting me jump in. I'm glad I put my Santo Domingo turquoise on today. So no big deal. We just asked the students to synthesize this incredibly comprehensive, like huge swath document into bite-sized chunks that would help tribes sort of conceive, think about, actually operationalize the declaration into tribal law. There's a number of different motivations going into this that I think we'll talk about more, right? That the declaration is really geared towards nation states. And yet tribal governments are not a nation state, at least conceived in this settler colonialist framework, but do retain certain sovereign responsibilities towards Indigenous people, while also proving to be a very effective advocacy tool for implementing the declaration in lots of different ways. So our attempt was to break the declaration down into a couple of different subject matters. We had each of the students take those subject matters, try to research what the current state of that subject matter, such as religious freedom or the well-being of children or climate change, gender rights, what the declaration had to say about that subject matter, and what current US law has to say about that subject matter as it relates to Indigenous peoples. This was like almost a laughable assignment. It's so broad and so just so deep and complex. The law students did a brilliant job. They each put together a really comprehensive memorandum that not only provided really succinct legal analysis, but I think, as all of the attendees here know, there's so much different social, historical, intersecting contexts that are all relevant here. And I think the students did a really good job synthesizing that. So now we are attempting to synthesize all of those memos into one workable toolkit that will be freely available to all tribal governments and to everybody, but it's really targeted towards tribal governments about what the declaration can do for tribal law. To really speak to that, the toolkit highlights tribal law as it exists today. We highlighted tribes that have actually endorsed the declaration or fully implemented the declaration explicitly into tribal law. But we also tried to identify tribal law that, even though it didn't specifically cite to the declaration, has tribal law that is very much in the spirit of the declaration, very much takes a human rights approach to its tribal law. And so we hope that through these examples, while not necessarily models, but inspirational examples about how tribes can think about what the declaration can do for tribal law. So to spin it back to the panel, we actually have two really on-point questions in the questions box regarding what a tribe or a tribal Alati association, how they might implement the declaration. The question specifically asked to the tribal constitution, but I think we know there's lots of different options. And also how Native nations can get involved just generally.
Great, thank you so much for that, Lauren. I really appreciate it. Walter, would you like to begin by speaking a little bit to that and the importance of implementing into tribal law, and as a tribal leader, maybe some ideas for people out there who are thinking this is something they might want to undertake in their own tribal community?
Yes, thank you very much. And congratulations, and thank you, UCLA and Lauren, for developing this tribal toolkit. I think there are many ways to begin implementing this declaration. And one of them is a legislative path, a legislative movement. And in that regard, in North America, we can look to the landmark law that was passed in late 2019 by British Columbia for that province. They passed a law that endorsed the declaration and directed the lawmakers in the state to align all of its laws with the declaration. And this is the very first statute of its nature in North America. And I think it provides a model for other states in our nation, as well as possibly federal legislation. And so to achieve legislation as a tactical matter of implementing this declaration in the United States, I think we're looking at the nature of legislative movements. And those legislative movements, I think in this instance, ought to properly begin with our tribal governments. It's just like that saying, that we're all familiar with: if you have to exercise your sovereignty or lose it. I think it's very same thing with human rights. You have to exercise and embrace your human rights or stand to lose them. And so in trying to coax the government, the federal government, to sit down in partnership with Native people and develop a national plan to implement the declaration, I think a lot of that work begins at the tribal level, on the grassroots level, nation by nation, to enact tribal legislation similar to the British Columbia that endorses this declaration and calls on state and federal jurisdictions to do the same thing. Because first of all, if our Indian nations don't endorse the declaration and these human rights, why should anyone else in our country if our own tribes don't? So I think that's a logical starting place. And if we can get 50, 100, 200, 300 tribal governments to pass laws along this nature through their tribal councils and lawmaking bodies that embrace human rights, call upon the states and the federal government to do the same thing, this is going to generate a legislative campaign. And along the way, it will require that our tribal attorneys, or our tribal leaders, and our tribal members be educated about the declaration so that human rights are on our lips, at this point. And so this toolkit that UCLA is putting together for the national project is an informational document aimed at tribal leaders, tribal council members, and tribal attorneys to educate them about the declaration and providing a model legislation for each tribe to consider to pass a law endorsing the declaration, maybe aligning tribal law with it, asking other jurisdictions to do the same thing, to establish some legislative precedent. And this is where the rubber hits the road here as far as beginning our legislative movement. Let's start grassroots with our own tribal nations where it belongs and move outward from there. And we won't stop this campaign until it reaches Washington, D.C. Along the way, we hope to educate the state governments because just like in the province of British Columbia, it took it upon itself to pass this law. It did not wait for the National Parliament of Canada to do it. It made a legislative precedent. Similarly, in the state of California, might be low-hanging fruit because of the very powerful and sophisticated tribes in the state of California, and California being one of the last true bastions of liberal thinking in our country. Perhaps California could be the first state in the Union working with its tribal leaders to pass a law of this nature. And if California does it, the rest of the nation's going to sit up and pay heed. And if all of the tribal tribes in California pass laws endorsing it, that's going to send a signal to the rest of Indian country to wake up and start passing our own laws. And the tribes can then also begin working. Well, I mean, not only self-educating themselves, but working with the national project hand in hand. And thus begins a great American social movement. And I think it starts at the tribal level with this toolkit. So that's my thought on that.
Great. Thank you so much for that, Walter. And for those of you who are out there watching, we are working on the toolkit and we are going to try to get it out to you. We have some incredible examples in the toolkit of tribes that have already started to go down this road in a variety of ways. The Muskogee Creek Nation, for example, has translated the declaration into its own language. And there are other tribes that have done other past resolutions or adopted the declaration in whole or part in other ways. So one final question, Kristen, before we open it up to the floor, because I know the audience has a lot of questions. I just wanted to give you a chance to say a word, and I think this ties in with the declaration having been translated into Creek, gives you a chance to say a little bit about the work that you're doing on language rights and how rights to Indigenous language tie into this overall project, because I think there is a synergy here between protection, and Walter's also tied this in terms of Native people protecting their own culture and living their culture in parallel with this kind of work that we're doing, and how language fits into that, and language as an Indigenous right and a human right under the Declaration, and how we might think about that in terms of this larger project. But then we'll open it up to broader questions.
Thank you. And thank you, everyone, for the great discussion. And Lauren, I'm glad that you hopped on to talk about the toolkit, and thank you for your great work supervising our students over the summer. So I guess I'd like to say 2 points about language, and maybe the first one is broader than the second. And one of the really important aspects of implementing the Declaration by Indigenous peoples is to interpret the Declaration vis-a-vis tribal people's own cultures that are uniquely expressed, of course, in their languages. And Professor Riley and I have actually done a lot of research on this topic. We wrote an article called Indigenous Peoples and the Jurisgenerative Moment in Human Rights, and maybe we could have a link to that in the chat, where we really wanted to show how Indigenous peoples have the opportunity to make the Declaration their own instrument. And all legal instruments, like the US Constitution, like any treaty, they must be viewed, in my perception at least, as living documents, so that they're responsive and meaningful to their constituents. And the declaration itself, can't be just some faraway document that was created in Geneva, if it's really going to give life and give voice to the concerns of tribes in the United States. And so in our research, we looked at a number of examples, and this was already 5 or 6 years ago, of tribes that were taking provisions of the declaration, let's say self-determination or water rights, or child welfare, and thinking, what do those key terms mean in Navajo or in Cherokee or in Hopi? How is it that we honor children in this tribal community? Or how is it that we protect water rights in this particular clan or religious or ceremonial purpose? And I think those actions and those processes of interpretation are really what can make the declaration responsive to the particular contexts of tribes in the United States. Now, to make that possible, at least on one level, does require having knowledge of Indigenous languages, because we all know that some concepts truly are uniquely expressed in the language. And Indigenous peoples' languages have suffered so much over the last several hundred years, and many of them have gone dormant. The United Nations General Assembly has declared the International Decade of Indigenous Languages from 2022 to 2032, and it is meant to give the world community the opportunity to realize Indigenous peoples' language rights as articulated in the Declaration. And just briefly, those include the rights to use, revitalize, and transmit Indigenous languages. I think the vision will be shaped specifically by each tribe. The Shawnee tribe, under the leadership of Chief Ben Barnes, has declared a Shawnee decade to revitalize its language. But I think this is a tremendous opportunity for tribes to engage with the world community of Indigenous peoples to reclaim their languages in ceremonial and cultural uses, but also across the board, from legal interpretation to economic and political contexts. I am doing a lot of writing about this with my partner, Alexei Sikarev, in Russia, comparative work, and international engagement with UNESCO and other bodies. We'll have lots of information about that on the UN Declaration site. And you're absolutely right, Angela, that it goes hand in hand with this entire human rights movement and a truly vital vision for the future of Indigenous peoples in 10 years.
Thank you so much, Kristen. All right, we have some time left, and I would love to turn it over to our audience for questions. Lauren is going to help me in terms of pulling those. So Lauren, would you mind posing a couple of questions to our panelists to answer however you all see fit?
We have a lot of substantive questions, so I'm just going to start taking away at them. Digging in a little bit into the specifics of the declaration, and coming from a former director of the Tribal Legal Development Clinic and a current justice on the Hopi Appellate Court, Pat Sikukwaptua, does the declaration speak to transnational corporate social responsibility with respect to Indigenous land or cultural rights in any way? The question pops up given the current tug of power between governments and corporations globally.
Walter, would you like to respond? Or, the law professor in me is dying too, but I'd like to defer to you first.
Well, I think that it would probably apply to the extent of any governmental involvement or partnership with those corporations, and impose the human right obligations on the government, as similar to federal undertakings, where a federal corporation is engaged in needs a federal license or uses federal funding or some federal nexus, that I would presume that to the extent that the human right framework of the Declaration, were it part of the law of the land, that it would be binding on the government and its undertakings, with these transnational corporations. So that would be my answer, and certainly if that were the case, then it would not be so easy for these transnational corporations to run roughshod over indigenous peoples, because we would be protected, our lands and our environments and our habitats and water supplies and etc. would be protected by inherent human rights that are protected by the state, recognized and protected by the state, and they would not be so easily trammeled upon. So that's my thought. I don't know that there's anything in the Declaration that would apply directly to a corporation or to an individual person, actor, I guess, but at least to the extent that the state is involved, it would be subject to human right obligations that it currently is not. So that would be my answer. To a very difficult question, I might add.
May I chime in just briefly? And I think Walter's absolutely right. Human rights obligations fall on states. And to the extent that corporations, whether multinational or not, are private actors, they're not directly bound. But this is an area of a lot of advocacy and work today. There's a line of cases that I think we should start looking at in the United States that comes from the Inter-American system, the Court and Commission on Human Rights. And all of those are cases where indigenous peoples have suffered when a corporation, whether mining or other extractive industry, has received permission from a national government to engage in whether it's mining or timber or whatever it is on indigenous lands, and has done some injury. And as Walter said, that nexus of government permission is when human rights liabilities are potentially triggered. And those human rights provisions may go to, injury to individuals, violation of land rights, and they may also, as in the Inter-American Commission cases, give rise to monetary judgments to clean up land or restore the loss of human life or injury and so on. More prospectively, I think Pat's question about corporate social responsibility is kind of how the private industry is dealing with this set of norms. And I think the idea of free prior informed consent, even though it's a public law doctrine in a sense, is entering into the private sphere as more and more corporations are adopting their own standards for obtaining consensual relationships, benefit sharing, and ongoing relationships with indigenous peoples around the world. And tribes themselves in the United States have the opportunity to shape that by publishing their own protocols, laws, and expectations on free, prior, and informed consent, and negotiating the kinds of arrangements that they want to have with corporations doing business on their lands. And I think they increasingly have leverage through this set of cases I mentioned, although they're from this region, not this country, but also the evolution of norms that seems to favor corporate responsibility in this realm. So thank you.
Sort of related to that, you brought up, other international documents at play here. We have a question. How do you see the Declaration working with prior international policies, including intangible heritage, or does the Declaration supersede these?
Is this question from Preston Hardison?
This is from Teresa Berman.
Oh, great. Okay. Well, thank you. We recently just had a series of webinars in which some of you were involved with the World Intellectual Property Organization and the Native American Rights Fund and Professor Riley and other IP experts. And Preston, who's a major leader in this field, had asked some tough questions in that setting too. But the short answer is that the Declaration is an interpretive instrument for all international covenants and treaties when they affect and impact Indigenous peoples. And there is a series of treaties or some other sort of instrument being negotiated in the WIPO Intergovernmental Committee process that may well regulate Indigenous peoples' traditional cultural expressions, traditional knowledge, and genetic resources. And the provisions of the Declaration that speak to cultural rights, in particular traditional knowledge, as in Article 31, those are absolutely coming to bear on the negotiation process and hopefully on the resulting treaties. I shouldn't call them treaties. They may not be treaties. They may be declarations. They may be guidelines. We don't know what they're going to be yet. Along those lines, Professor Riley is actually more deeply involved in this work than any of the other panelists, I think. So we should probably pass the baton to you on this question.
Nope, I'm happy to defer to you. Thank you. Walter, do you want to say anything on this point?
What she said.
Exactly.
Yes, she's far more knowledgeable than I on that subject. I have to have a caveat of my participation is that I am almost exclusively a domestic law practitioner, you know, and do not have a wide breadth of international law experience. So I'll just say that caveat here.
Yes, I'm happy to have Kristen be the last word on that too. Lauren, do we have more questions?
Why, yes, we do. So two sort of related questions. Is there a reason or reasons that tribal governments are apprehensive about the Declaration beyond just unfamiliarity? And sort of related, do you see more success in the United States leading with legislative adoption of inherent human dignity, or do you see leading with full adoption of the Declaration to encourage legislative compulsion or obligation under international law? So two sort of like different advocacy points.
Well, I think that we should press on all fronts: legislative, a smart litigation strategy, as well as agency advocacy as well. I don't know, you know, usually if one branch of government is more receptive than the other, we can pick and choose, you know, and just nurse this strategy forward. And what was the first question, Lauren? I didn't catch that.
If there are any reasons as to why tribes may be apprehensive about implementing.
Yes, that's a good question. And as the questioner alludes, the first problem is lack of knowledge about this. What are human rights and what is this declaration? So it's a self-education thing. And I believe this toolkit is going to help on that. The second concern that I envision for tribal leaders is if we endorse this declaration and adopt it as a matter of tribal law, what impact will that have on our existing statutes and also going forward? And so I think that this would require the tribal leaders to consult with their attorney generals or their tribal attorneys to get a legal assessment of the impact of that proposed legislation on existing tribal laws. I would presume that this would be, they would largely be compatible, but it would be the first question I would ask. As mentioned earlier, I am the new president of the Pawnee Nation Business Council, and I hope to when I get my feet on the ground settled a little bit more, to present this toolkit when it comes out to my council and to our Attorney General, and probably hold a education session with the council about the declaration, why it's needed, how it plays a larger picture in this social justice law reform movement, what the Pawnee Nation can do. And then we would probably refer this model legislation to our Attorney General to give us a legal opinion as to if we enact a model law, how is that going to impact Pawnee statutes, and how will it impact our government? And if we can wrap it in a seamless way and make sure it's compatible with our statutory framework, why I think I would hope our council would pass a law of that nature, and work proactively with the national project to provide some leadership on getting this legislation ultimately enacted by our federal government.
Did you want to add anything, Professor Carpenter?
No, I'm happy to defer to President Echohawk on the tribal leader questions. I think you said it beautifully.
Well, I think we have time for one more question, and I apologize to all of the other great questions out here and sincerely appreciate you asking them. But to bring it back to Oklahoma, what impact do you see the Mcgirt decision having on the declaration, if any?
We direly need the protection of inherent human rights to protect our sovereignty, our self-determination, our self-government, as well as our environmental rights. The Mcgirt decision, which in a nutshell, the Supreme Court ruled that the original reservation boundaries of the Muskogee Creek Nation have never been terminated, but they remain intact, and that therefore the state has no jurisdiction to prosecute Indians for crimes committed within those original boundaries, which is about 5 or 6 counties, including Tulsa, Oklahoma. That prompted a backlash by the state of Oklahoma. And we have a senator here in Oklahoma, Senator Inhofe, a very right-wing person who is known for creeping into the Senate chambers at midnight and attaching anti-Indian riders to non-germane pieces of legislation. He did that in the 90s to prohibit tribes from exercising treatment as a state under the Clean Water Act, after the Pawnee Nation received that status under the Clean Water Act. So back in 2005, Inhofe creeped back into the chambers under the dark of night and tacked on a rider that said that if the state of Oklahoma ever requests the EPA to exercise regulatory jurisdiction in Indian country, that EPA must permit that, quote, notwithstanding any other law. And so in response to the Mcgirt decision, the state of Oklahoma, Governor Stitt wrote that letter to EPA in the end of August, and EPA rushed. It gave the tribes about 1 or 2 days notice to do so-called government-to-government consultation, and before most tribes were even able to gear up for such consultation on a complex matter, all of a sudden cut off consultation, and we got a letter today saying they approved Oklahoma's request, an assault on our jurisdiction affecting all 39 tribes of this state. giving the state regulatory powers, within our areas here. Very unjust, undemocratic rider, which is just an unjust end to a long unjust history here in Oklahoma. We were marched here on our trails of tears in the darkest chapter of American history. And now to have this rider ram this state rush of jurisdiction into our territories, and then seeing the Trump EPA, which has been busy dismantling environmental protections for the last 3.5 years. It worked nights and weekends and rushed overtime to approve that request and ran roughshod over our tribal consultation rights. This is why we need free, prior, and informed consent, and we need to protect our environmental homelands here through a human rights framework, because the state of Oklahoma, who would want the state of Oklahoma to protect our environment when they're run by big oil here in Oklahoma? So that's just a glaring, very egregious example of the need for a human right framework to protect these kinds of inherent human rights.
Thank you, Walter. Kristen, do you want to say a couple of words before we close?
Well, super briefly, after so many years living in what Walter has called the dark side of federal Indian law, I just think it's so exciting and promising that the Muskogee Creek tribe both has prevailed in the Mcgirt case, recognizing their treaty-based reservation boundaries, and is one of the leaders on implementing the Declaration on the Rights of Indigenous Peoples. There is just so much promise here for meaningful self-determination, and I'm really just thrilled to see the Oklahoma tribes taking the lead here. Thank you.
Thank you so much. I would be remiss if I didn't close with a couple of words. One is I want to just thank you both so much for being here. You're an inspiration to us all, and we're deeply honored to share this digital platform with you. So you're brilliant and amazing, and I know our audience shares this as well. So thank you for that. I also just wanted to mention some of the news that came out of UCLA in the last week or so, for those of you out there watching who may be considering law school or know people who are considering law school, in addition to the enormous generosity of the San Manuel Band of Mission Indians, which is funding our Tribal Legal Development Clinic, building on that foundation, we recently received a $15 million gift from the Federated Indians of Great and Rancheria to go to scholarships for students who want to work in Native law and tribal law. So if you're out there thinking about doing this, please think about UCLA, and we're deeply indebted to all of our supporters in Indian country and beyond as we continue to try to do this work and carry forth the good work and the example that's been set for us by so many, and principally, Walter Echo Hawk and his cohort. So thank you all for being here. To our audience out there in Indian country, we're speaking from Tongva territory here in unceded Tongva land in Los Angeles County. So thank you for being present with us today. Miigwech. Bye, everyone.
Thank you. So long.